Good morning, everyone. Let's get things started. Welcome to the final round of the 2021 first ever virtual Roger J. Traynor Moot Court competition. Please forgive the cliche, but I wanted to start by saying I wish we were all able to be together in person. But I am so grateful as the Traynor administrator for everyone's cooperation in making this remote event so successful. A huge part of that was because of our host school, the University of West Los Angeles School of Law. So I would like to just take a moment to thank the president of UWLA, Robert Brown, and the dean and provost, Jay Frickberg. They generously allowed us to use the physical campus in a safe, socially distant way so that we could supervise the Saturday rounds yesterday with our bailiffs in person. So thank you so much. Jesse Aldava, who is our Director of Institutional Research and E-Learning, with Mauricio Canav, Library Services Manager, set up all the Zoom rooms and troubleshot for us. So thank you to them. Thank you to our able and dedicated student bailiffs, Jacqueline Anderson, Arpi Sislian, Yassi Terani, Shushan Yeremian, and Ani Zakarian, who came yesterday and spent the day with us and made the entire competition possible. And thank you to all the judges who came yesterday and devoted their entire Saturday to this event. The Traynor was made possible by a generous grant from the Gisnet Mandel Moot Court Trust. Special thanks to Patrick and Ingela Pigot. Lunch for the judges was made possible by our gold sponsor, Esner Chang and Boyer. So special thanks to Stuart Esner. And a reminder that everything about the Traynor, there's a competition program, a synopsis of the case, the list of winners, past winners, everything can be found on our website, traynormootcourt.org. So check that out there. I want to make sure we're recording. We are. Great. Well, now what we've been waiting for, our final round between Team 3 for appellant and Team 10 for the respondent. Today, as our judges, we are very excited and honored to welcome the Honorable Arthur Gilbert, the Honorable Helen Bendix, and the Honorable Elwood Lui. And acting as our bailiff today is David Glassman. He is a decades-long supporter of this competition. We thank him. And now we turn the proceeding over to him.
Good morning, everyone. Welcome to the final round of the 2021 Roger Traynor Memorial Moot Court Competition. This is the case of People of the State of California versus Peter Prescott. The appellant, Peter Prescott, is represented by Michael Sulemazian and Catherine Willis. The respondent, State of California, is represented by Patricia Snyder and Dalia Maayah. Each team has a total of 30 minutes. I will keep time and I will display the intervals of time as I reviewed with the advocates. I would like to first, before we begin, ask each advocate in the order of presentation to introduce themselves and to spell their name, please, starting with Mr. Sulemazian.
Good morning, Your Honors. Michael Sulemazian, M-I-C-H-A-E-L, last name S-E-U-Y-L-E-M-E-Z-I-A-N.
Good morning, Your Honors. Kate Willis, K-A-T-E-W-I-L-L-I-S.
Good morning, Justices. Patricia Snyder, P-A-T-R-I-C-I-A. Snyder is S-N-Y-D-E-R.
Good morning, Your Honors. Dalia Maayah, D-A-L-I-A. Last name M-A-A-Y-A-H.
Thank you all. Mr. Sulemazian has requested 2 minutes of rebuttal. Unless there are any questions or if the court is ready to proceed, Justice Gilbert, let me know. And if so, I will ask Mr. Sulemazian to proceed.
I think we're ready to proceed. Thank you.
Thank you, Your Honor. Mr. Sulemazian, your time.
Well, yeah, excuse me. I just want to make a few preliminary comments, I want to welcome you all on behalf of my colleagues, Justice Bendix. Justice Elwood Lui is the administrative presiding justice of the entire Second District. And he and I have known each other for years, and we're all good friends. We all know each other, and we're on different divisions of the Second District. I thought that might be of interest to you. Now, we tend to be somewhat of an active court, depends, and we may interrupt you. I know that may be annoying, but that's what happens in real life. And the reason we do that is because we we might have an idea about the case, and it helps you because you know what our thoughts are about the case. Now, how do we interrupt you on this Zoom meeting? We generally put our hands up like this. That's what I do in my division. So if you see a hand coming up, you got to sort of be aware of what's on the screen because we might want to interrupt you. We try not to, but on certain occasions, we have an idea and we want to pursue it. Okay, with that, with those few comments in mind, let's begin with Mr. Sulemazian. Go ahead, sir.
Sulemazian, you may begin.
Good morning, and may it please the court. My name is Michael Sulemazian, and I, along with my co-counsel, Mrs. Kate Willis, represent appellant, Mr. Peter Prescott. I will be addressing the excessive force issue and the jury instruction issue, and Mrs. Willis will be addressing the ability to pay issue. We have asked this court for 2 minutes of rebuttal.
Sure.
The criminal justice system failed Mr. Prescott. From the manner in which he was arrested all the way through his treatment at the sentencing hearing, Mr. Prescott was ignored by both the officers and the trial court. This was a miscarriage of justice. Mr. Prescott's Penal Code Section 69 convictions should be reversed because both Officer Dawson and Officer Drucker used excessive force when arresting Mr. Prescott. The facts of this case—
Excuse me, was Mr. Prescott violating any kind of law, however minor that law may be, during this time when they first confronted him?
Your Honor, the officers first stopped Mr. Prescott for potentially violating a traffic provision of discarding his ashes of a cigarette while he was walking down the street.
What do you mean by potentially? He was or he wasn't?
Your Honor, the officers saw Mr. Prescott smoking a cigarette and decided to stop and either warn him or cite him for discarding his ashes. So the facts of this case began with a man who went to the store to purchase some cigarettes. It ended with Mr. Prescott being tased, tackled, and punched in the head repeatedly. How we went from Mr. Prescott simply walking down the street smoking a cigarette to face down on the ground receiving multiple blows to his head by 2 officers is central to this issue. As we go through this analysis, it's important to consider what an objectively reasonable officer would have done here and whether or not we would have had the same results. Officer Dawson and Officer Drucker's escalation of violence towards what was a cooperative and calm defendant is more than unbecoming, but it is excessive force. To determine if excessive force was used, courts apply the Fourth Amendment reasonableness standard to balance the nature of force used by the officers against the relevant governmental interests at stake here. Although this reasonableness standard does allow for split-second decision-making by police officers, we can see that in this situation, not all of the decisions were split-second. Officer Dawson and Officer Drucker had many opportunities to de-escalate the situation and keep a calm confrontation calm.
Didn't he resist? Excuse me, irrespective of how unreasonable you may think the stop was, there was some resistance on the part of Mr. Prescott, wasn't there?
Yes, Your Honor. The stop, we don't contest that the stop was unreasonable. Rather, it was the manner in which Mr. Prescott was arrested that was unreasonable.
Right, but did that happen in a vacuum? When the officers approached him, didn't he, or they were talking to him and even just approached him, didn't he make some kind of tense up or try to pull away?
Yes, Your Honor, Mr. Prescott did tense up and pull away, but only once Officer Drucker tried to grab him without warning. Officer Drucker and Mr. Prescott were having a calm conversation about Mr. Prescott's newborn child. Mr. Prescott's actions in this.
Well, was it unreasonable for him to assume when he ran a warrant, he got his name, so he went to the car and ran warrants. And I think that's probably always what they're doing. They came back and they tried to handcuff him. It seems to me that at that time he had the ashes thing, how minor that was, plus an indication that he had outstanding warrants. So we have to judge that against the officer's conduct. What would you have the officers do? Say, stop, I'm going to handcuff you because you have outstanding warrants, and therefore I'm going to give you a warning, or should I just try to handcuff you and presume you're not going to resist by tensing up? So that's what's facing the officer, isn't it? Isn't that the correct assessment of the situation?
Yes, Your Honor. However, there are certain requirements that an officer must follow, and this is because the legislator has recognized that people don't always know that they're being taken into custody. Not all interactions with the police end with the suspect being taken in. And here, there was nothing that Mr. Prescott should have reasonably known that he was being taken into custody. This is why we have Penal Code Section 841 that requires that an officer clearly inform citizens that they're being taken into custody. Although there is no strict timing on when the officers need to do so, it was reasonable in this circumstance. The officers had ample opportunity to simply tell Mr. Prescott he was being taken under arrest.
What was the trial court's rationale for not granting the motion to dismiss the 1118 motion and sending it to the jury?
Your Honor, the rationale there was that there was conflicting evidence as to whether or not Mr. Prescott's behavior posed enough of a safety threat to the officers' concerns that they were therefore exempted from Penal Code Section 841's requirement.
Shouldn't that matter go to a jury to decide rather than a court as a matter of law?
No, Your Honor, because of the jury instruction issue in this case, we had the trial court improperly instructed the jury on Penal Code Section 841. And we can see that there is evidence in the record here that Mr. Prescott was behaving reasonably and did not pose a substantial threat. So when we balance the nature of force used by the officers against the governmental interests at stake, courts weigh three different factors to measure that governmental interest: the severity of the crime at issue, the immediate threat posed by the suspect at the time, and the active resistance and evasion of the suspect. So the severity of the crime here is these undetermined warrants that Mr. Prescott has. And courts have held that undetermined warrants are not alone enough to justify a substantial use of force by the officers. And this is because undetermined warrants can be for a variety of different crimes. They could be for misdemeanors or nonviolent felonies.
Excuse me, but doesn't the fact that there's an outstanding warrant contribute to an officer's assessment of risk to public safety or his or her own safety?
Yes, Your Honor.
They're not unrelated, are they?
Yes, Your Honor, you're correct. They are not unrelated. However, it's important that when Officer Dawson discovered undetermined warrants and didn't know what those were for, it was not enough for him to then be on a higher level of alert to employ a higher level of force. We can contrast this from if Officer Dawson had ran those warrants and discovered that Mr. Prescott was wanted for an armed, very violent felony. That is the type of warrant that would justify a substantial use of force. But when it's unknown to the officers, that is not enough. When we look at the second fact.
Does 841 come into play at just the very first interaction with the officer? Or could it come into play during the course of the arrest? The reason I'm asking is the fact that the officers appear never to have told the defendant that what the nature of his offense was.
Yes, Your Honor, you're correct.
And is their obligation is it a continuum of an obligation, or only when they first interact, you're pulling his hand back for it?
5 minutes remaining.
Yes, Your Honor, you're correct. This Penal Code
I'm
section
asking you, I
requires.
don't know the answer to that question.
Well, Your Honor, Penal Code 841 requires that at some point during the arrest, the officers inform the arrestee of the intent and cause. Here, we would argue that the officers in this case should have said that at the beginning. However, even if they did not do it at the beginning, they had the opportunity to do so at any point. And throughout the entire course of these events, Mr. Prescott asked several times, what is going on, what is happening, and the officers ignored Mr. Prescott. Penal Code Section 841 especially requires an officer to inform of the intent and cause when the arrestee is actively asking the officer what is happening. The officers at trial here testified that they simply did not remember what Mr. Prescott was saying throughout this interaction.
So you would favor having him be told that before they secure his custody? In other words, before they put the handcuffs on him, you got to tell him what's going on. Is that what you're saying?
Yes, Your Honor. In this case, given these circumstances, prior to grabbing...
We don't know what what the outstanding warrants are. And the fact that he has an outstanding warrant could be minor, it could be serious. And so do you favor telling a arrestee, even on these unknown situations, that he should be told of the outstanding warrant before his physical custody is secured, or after?
Your Honor, we would still be in favor in this situation prior to grabbing Mr. Prescott, because I want to emphasize that these unknowns, it's not permissible for the officer to assume the worst in all of these circumstances. These unknown warrants could have been for a misdemeanor.
Let's take a look at, we're concerned about the safety of both the officers and the arrestee. Would it be better to have the arrestee be secured and then told what it is, or would you do it before and then there's a possibility of fleeing? I mean, we're talking of balancing the security interests of the arrestee and the officer. You would favor still that telling the arrestee, before I put the handcuffs on you, you're being arrested for outstanding warrants, which we don't know about, but you have outstanding warrants. That creates somewhat of a danger.
Your Honor, even under that evaluation, if we said it was better for the officers to get Mr. Prescott's hands behind his back first, they still had multiple opportunities throughout the situation to tell Mr. Prescott he's under arrest and therefore comply with Penal Code Section 841. They simply refused to do so here. The officers said that they didn't have time to do that. However, they had plenty of time to repeatedly tell Mr. Prescott, stop resisting. When Mr. Prescott here was scared, and on reporter's transcript, page 358, Mr. Prescott testified to the fact that he felt like he was being attacked. Turning to the jury instruction issue,
2 minutes.
the trial court here improperly lightened the prosecution's burden with argumentative jury instructions. The standard
even if the officers don't have cause to stop and arrest Mr. Prescott, is there a responsibility on the part of the citizen just to submit to the arrest and then, instead of trying to resolve it by resistance on the street, resolve it in a court of law in a different way?
Your Honor, there is some responsibility on the citizen. However, it's important that the burden of this responsibility falls on the police officers to behave appropriately. We're here to evaluate Officer Drucker and Officer Dawson's behavior. Mr. Prescott acted reasonably as anyone would when he's grabbed without warning. That's not a reasonable behavior of the officers. So the jury instructions here were argumentative because the trial court completely omitted the 2 statutory exceptions to Penal Code Section 841 and simply emphasized for the jury that the officers may be exempted from 841 if the defendant's behavior was resistant. And it said when issuing these instructions that this arrest, otherwise lawful, does not become unlawful when the officers fail to comply with 841. This was argumentative, and it was not harmless beyond a reasonable doubt, given the fact that these officers were not exempted from this Penal Code Section 841 requirement. In light of all these considerations, we respectfully ask that this court reverse Mr. Prescott's Penal Code Section 69 convictions. Thank you.
Thank you.
And we'll next hear from Ms. Willis.
Ms. Willis, you have 15 minutes.
Thank you. Good morning, and may it please the court. My name is Kate Willis, and I will be addressing appellant's second issue, the trial court's failure to consider his ability to pay his fines and fees and the denial of an ability to pay hearing at sentencing. As my co-counsel described, Mr. Prescott faced a miscarriage of justice from his initial encounter with law enforcement to the jury instructions that would decide his fate at trial. The violation of his legal rights continued at his sentencing hearing. In addition to a prison sentence of 6 years, Mr. Prescott was sentenced to $640 in fines and fees. Mr. Prescott had a right to a hearing to dispute these fees based on his inability to pay them. However, the trial court failed to allow him to dispute his restitution as required by Penal Code Section 1202.4.
But let me ask you this. I understand the trial court didn't do that. What are the consequences of Mr. Prescott not paying the fees? Let's assume he didn't pay the fees. What are the consequences? What I'm driving at, would his jail time be increased? Would he be in custody if he didn't pay the fees?
Your Honor, no, his jail time could not be increased because the Supreme Court has previously held that is unconstitutional. However, not being able to pay the fines right away would result in a spiraling of Mr. Prescott's debt, because if a defendant cannot pay their fines and fees, eventually the court sends that into collection, and then those amounts grow and grow.
But that's
Yes.
a future problem, isn't that right? It's not a present day problem. It's in the
Correct.
future.
Yes,
So
Your Honor, that is a
At the time
future.
that the fees are imposed, how is there any restriction on him? It doesn't have any present context.
Well, Your Honor,
We're interrupting you because Justice
Please finish.
wants to
Ms.
follow
Willis.
up.
Interested in your answer. Maybe you'll answer my question while doing that. Okay.
okay, so I'll answer Justice Liu's question first. So the reason it is important to hold that ability to pay hearing immediately at sentencing is because that fine is due right away. And in the case People v. Duenas, which I'll talk about coming up, the court held that as a matter of due process, the defendant's ability to pay at that moment must be considered at this hearing.
Well, there are a few courts, including my court, does not agree with Duenas presently because, and one of the problems is the other prong of your argument is that the court must determine. I have a hard time with the concept of anyone but the defendant being able to bear the burden of payment, because I don't know what his resource, if I was a judge, I wouldn't know what his resources is. He should speak up and say, I don't have the ability to pay. And it's not presently a problem. It's when he gets out of incarceration, when those fees are expected to be paid. During the time of incarceration, he earns fees on working in the prison system. But I have a second problem with Duenas in the sense that how is a court supposed to make that inquiry? And have the burden of making that inquiry.
Your Honor, we are not suggesting the court provide the inquiry. The holding of Duenas is that this, as a matter of due process, this hearing must be held. And at this hearing, the defendant would bear the burden of presenting evidence on their financial situation and show whether or not they have the ability to pay. Then the court may take that into consideration when determining the fines and fees. And this is reflected in Penal Code.
I'm interrupting you, I'm sorry, because I think Justice Bendix has a question that will go to this very issue.
Well, you've mentioned 3 times it's a violation of due process. Why is it a violation of due process? He hasn't been denied access to the courts.
Your Honor, the holding in People v. Duenas that it is a denial of due process is based on the fact that unpayable fines place a much greater burden on indigent defendants than wealthier defendants. And the constitutional guarantee of due process is to ensure that everyone is treated equally under the law. But if you consider a defendant's ability to pay who has less money than one who has more money, that burden is greater on the indigent defendant, especially considering these collateral consequences that are a result of a growing debt. An indigent defendant may face total loss of credit for being unable to pay this debt, and as such, they may face a loss of their job or a loss of housing. And this not only affects them, but their families.
Okay. Now you said the burden is on who? Is it on the defendant or defendant's counsel to bring it up?
Your Honor, yes. Our position is that one, the burden is on the defendant to request this ability to pay hearing.
Okay, and then the burden of showing that, that's on the defendant?
Yes, it is our position that that is on the defendant, and this is in accordance with the penal code section that says the burden is on the defendant.
I'm going to interrupt you again. Let's assume that happens and the judge says, okay, you don't have to pay the fine. Does that mean he doesn't have to pay the fine ever, right?
Yes, Your Honor.
So if he wins the lottery or he inherits from a wealthy uncle, too bad he doesn't have to pay.
Yes, Your Honor. If we are looking at the defendant's present ability to pay, which is consistent with the holding in Dueñas, then it won't matter in the future. And in Mr. Prescott's case, he's going to prison for 6 years, so his circumstances are unlikely to change.
Yeah, that could be. You know, it's interesting. Three of us are from three different divisions. And I think we all agree. I don't know if Justice Bendix does. I think so.
I wrote to Paris, so I have a different take a little than Justice Ofsted did in division.
Yeah, I agree with Justice Lui in the sense that we think Dueñas is wrongly decided. We don't follow it. The Supreme Court may have a different point of view, and we're just waiting for the Supreme Court to finally decide the case so we can move on with some other issues. But go ahead.
Yes.
Can I follow up on this? Because why isn't Dueñas confined to its unique facts? And the statement behind my question is that her poverty led to her criminal conduct, driving with a suspended license. But in this case here, no, I don't think one can argue that Mr. Prescott's financial situation led to the reason he's in front of us now.
Yes, Your Honor.
Why is Dueñas, again, focusing on the due process? You're saying it's a matter of constitutional law, since every defendant's entitled to an inability to pay hearing. I have trouble with that concept because I don't see how access is being denied to the court but I'm going to ask you to answer my first question, which is why shouldn't Dueñas be confined to its very unique facts?
Yes, Your Honor. And I know the court has raised this in various cases, but yes, Ms. Dueñas' circumstances were very extreme and quite tragic at that. However, due process is a constitutional principle, and that is universal to all criminal defendants, regardless of their circumstances. And furthermore, a defendant's circumstances cannot truly be discerned unless they are given that opportunity to show whether or not they can pay. And then can you repeat your second question, please?
I think you answered it.
Okay. I also wanted...
Well, what's wrong with this? What's wrong with this? The court can provisionally say you've got to pay these fees. And when he gets out of prison at an appropriate time, make a motion to the court and say, look, I can't pay these fees. While I'm in prison, what I get for sweeping the floor or something is minimal. I'm never going to be able to pay it. But look, I'm still in this condition. Would that be an undue burden and a violation of due process?
Your Honor, I see how that could be a potential solution. However, I believe if we're looking at a universal solution and one that could potentially be, well, the Dueñas court recommended this statute 1202.4 be amended because those procedures are unclear. And in response to, staying the fines until one is out of prison, not every defendant in this situation will go to prison. Ms. Dueñas was only sentenced to a misdemeanor. So it's more, it makes more sense to have the process be the same for every defendant so you can address it right there at the sentencing hearing. And hopefully the legislature, yes.
Excuse me. Many defendants are sentenced to decades in prison. The fees here were the lowest that the court could have imposed. Why couldn't they, going back to Justice, I think it was Justice Gilbert's question, why would not his prison earnings be sufficient to pay those fees? I believe that's the Johnson case. Why isn't
Yes.
it harmless error?
Yes, Your Honor, 2 points on that. Actually, his restitution fine was above the statutory minimum, which is $300 for a felony, and he was given $500.
Apologize. I misunderstood. All right, but the same
Yes.
point.
But regarding prison wages, according to the California Code of Regulations, I believe this is Title 15, Section 8006, there's a pay scale for prison wages, and it ranges from 30 cents to $1, depending on how the prisoner may move up in their prison job. So in 6 years, he may or may not, earn that amount that he owes. However, also not every prisoner is eligible to work in prison, and we don't know Mr. Prescott's situation. But I also want to highlight the fact that often defendants in this situation, indigent defendants, not only do they need to worry about paying off their fines and fees while they're in prison or after prison, but Mr. Prescott has a newborn child to support, and many defendants also use prison wages to support their families and to support themselves while in prison. You need some money to buy necessary things. So
Ask you a question, and again, it may not be, maybe it's not. There's several things that the criminal law imposes. If you get a DUI, you have to install, let's say, a machine in your car so you breathe into it before you can drive, and check your blood content. All those kind of things. You're saying that every time the law imposes, the legislature has imposed such a condition to probation, it's a due process violation, the person can't afford it?
yes, Your Honor. However, that's a different issue than in Dueñas.
Why is it different?
Because that, I believe that was already decided by the Supreme Court, and the case, I believe, is Bearden. Yes, my apologies. In Bearden, the question was, can you jail a defendant or sentence them?
No, I didn't say jail them. I didn't
Yes.
say it can be you jail. But my question is, if you get the privilege of probation, if you're indigent, let's say, or poor, I assume you're going to argue that your court can't condition probation on requiring someone to install a breathalyzer, whatever they call it, in your car because they're poor and they can't afford it, and therefore they don't get probation. They have to go to county jail, let's say.
Your Honor,
I'm trying to think of the logical conclusion of your argument, because there are many things that the legislature has imposed when someone is convicted. And my question is do you think that due process requires an ability to pay hearing for each one of those? If someone is, let's say, if someone has a public defender.
1 minute remaining.
Your Honor, I would argue that appointment of a public defender, such as in Mr. Prescott's case, should create sort of a presumption of indigency. But our position is only regarding the fines and fees element. There's, endless things that could be discussed, but I would like to point you to People v. Bearden, the Supreme Court case I mentioned, and that court held that while there is this government interest in punishment and deterrence for people who commit crimes, that interest should be served by alternative means that don't violate an indigent defendant's due process rights, and that deprivation of 14th Amendment liberties is not permissible simply because a defendant does not have the ability to pay a fine.
Would you agree? Well, would you think this would be appropriate? If you can't pay, you're going to have to do some community service. You're going to have to do some work cleaning up parks and do something like that.
Your Honor, I see I'm out of time.
I'll let you finish. Go ahead.
Okay. Yes, Your Honor, I would argue that is a reasonable solution, as long as the burden isn't greater on a poor defendant than a wealthy defendant. That's the whole issue at stake here.
Of course, the wealthy defendant wouldn't have to do community service. But
Right. So it could possibly be unequal treatment in that situation.
Okay, time is up. Thank you.
Okay. Thank you. May I just briefly conclude?
Well, all right, you got 15 seconds.
Yes, I just want to emphasize the remedy we're requesting here, which is that this court stay Mr. Prescott's fines and fees until it can be considered on remand at an ability to pay hearing where he can present evidence on whether or not he can pay them.
Okay, have another hearing on that. Yeah,
Yes.
Thank you.
Thank you.
The first advocate for the respondent is Ms. Snyder. Ms. Snyder, you have 15 minutes when you're ready.
Hello, Ms. Snyder. Welcome.
Thank you. Thank you. Good morning, justices.
Good morning.
May it please the court, my name is Patricia Snyder, representing the respondent, the people of the state of California, together with Ms. Dalia Maayah, co-counsel. I'm going to demonstrate why the appellant's arrest was lawful and his conviction should be affirmed. Ms. Maayah will demonstrate why the court was not required to hold an ability to pay hearing prior to imposing fines and fees.
Yeah, go ahead.
Appellant contends that he was ignored by the deputies and that the use of force against him was unreasonable. But the jury in this case found substantial evidence that this arrest was lawful because
Of course, the question is, should this have even gone to the jury? I'm going to back up and ask you something right away.
Sure.
People can smoke in public, right?
Yes.
Yeah, outside. I mean, a restaurant might understand that. And when people smoke, how do they get rid of their ashes? What do they do?
They ash in an ashtray or a proper ash.
Okay. Oh, really? Well, I've walked down my street and many streets, I don't see any ashtrays around. And even though I'm not a smoker, there still are, a lot of smokers left, and I see them flicking their ashes. What are they supposed to do?
I understand what you're saying, Justice, and the officers do have a right to make pretextual stops. And when they stop, yes, Your Honor,
What do you mean by a pretextual stop?
Well, if they have a reason to stop somebody for the violation of a code, in this case, it was a vehicle code that requires that people do not ash, burning embers on the sidewalk and outside of a proper receptacle. So that is why.
If they're walking down the street and see somebody well-dressed in Beverly Hills on Cannon Drive, for example, smoking a cigarette, wearing an Armani suit, looking at one of the fancy stores and has a cigarette, do you think any officer is going to stop that person in real life? Let's be honest. You think that's going to happen?
Those were not the circumstances that occurred in this case. So I could speculate as to what an officer in Beverly Hills would do under those circumstances, but that is not what happened in this situation.
Okay.
So these officers did stop him for ashing on the sidewalk, and they began a conversation with him. And now they ended up running his name to check for warrants. And now he claims that the arrest was unlawful because the officers failed to comply with 841. But under the circumstances, as I will highlight them, full compliance with 841 was not required. And the officers' use of force was reasonable because it was in direct response to appellant's forceful resistance. And finally, the jury.
Right.
Yes.
Miss Justice Bendix, please.
So why couldn't the officers, when they were handcuffing him or before they tased him the second time, tell him he's being arrested for the outstanding warrant?
Well,
in other words, there's a relation between his resistance and not knowing why they were stopping him. I think that's what Justice Gilbert's questions are. I mean, most people would not expect to be confronted by two policemen and almost put in a handcuff till he wouldn't let him, just because he flicked ashes on the sidewalk. So I'm concerned about that. This is a continuum of conduct, and at some point, why didn't the officers just tell him why they were confining him? I don't want to use the technical term. Just
in
trying to
fact,
do him.
Deputy Drucker testified at trial that when he received the 1015 code from Deputy Dawson, he turned to appellant and said, put your hands behind your back so you can be handcuffed, so you can be arrested. So under those facts, which are the facts that the jury presumably believed and convicted appellant based on, Deputy Drucker did tell appellant that he was under arrest.
Yeah, but
And
doesn't
at that
the statute require you to say what the offense was?
It
Yeah.
does. It does. And as soon as Drucker said, put your hand behind your back so you can be arrested, appellant's demeanor immediately changed. He immediately started backing away and saying no. And so based on Deputy Drucker's training and experience, he believed that appellant was going to flee. So he
What
reached
about,
out.
yeah, what about, I'm sorry, I'm interrupting you, but that's
Okay.
kind of in real life, in real court.
No, it's great.
What about penal code section? What is it, 841?
Yes,
Aren't you supposed to tell them why you're arresting them?
you are. But my point is
I'm
that the
arrested,
deputies,
wait, let me finish, please. I know you want to get it out, but judges often do this. But shouldn't they have said, we're arresting you because you have warrants, and tell them what it is? That whole situation might have been diffused. Isn't he required to do that? He admitted on the stand he didn't do that.
they were not able to because appellant immediately began to forcefully resist them. Under ideal,
Wait a minute, they didn't tell him. If they didn't have to do anything, they said, we're gonna have to arrest you because of you have outstanding warrants. You said he didn't give him a chance. He starts handcuffing him immediately.
Deputy Drucker told him to put his hands behind his back so he could be handcuffed and arrested. And then
Yeah,
appellant immediately began to resist. And
but he didn't know what, my point is, he didn't know why the officer told him to do that. Doesn't the officer have an obligation under the code section to say what I just said? We're going to arrest you. We have to arrest you because you have warrants.
yes, but the case law illustrates that the officer's uniform is sufficient indicia to prove their authority to arrest and to satisfy the requirements under 841. These deputies were in full uniform with their badges visible. They were in a marked
I
sheriff's.
gotta stop you again.
Mhm.
Are you saying that 841 only applies to uniform officers, but not to plainclothes detectives?
No.
Well, isn't that the logical import of what you're saying?
I am saying that it would be more important to comply fully with 841 where an officer is in plain clothes. But in the case of In re Ramon T, there was an off-duty officer in street clothes, and the court held that his badge, showing his badge to a group of teenagers he was trying to arrest, was sufficient indicia to meet the requirements of 841.
Did the officers ever, even after he was finally sustained, he was placed into custody, did they ever tell him what he was arrested?
They did not have the opportunity. This was a very.
Well, they got him in a police car and he's going in the back of the car and locked up. Couldn't they have said, well, you're being out, you had an outstanding warrant, that's why we arrested you? They didn't do that.
So appellant was not subdued until backup officers arrived on the scene. And even then they had to get a hobble on his legs to prevent him from kicking because of the amount of force he was using in resisting this arrest. And so after the backup officers arrived and they subdued him, they took him away, and Deputies Drucker and Deputy Dawson had no further contact with him. So that is why, yes.
Are you finished responding to Justice Louis' question? I didn't want to interrupt you.
Thank you, yes.
Okay, is there anything in the record to indicate that the defendant knew he had an outstanding warrant?
No, the appellant did not know that he had outstanding warrants, but he knew that they were running his name for warrants. He was standing there waiting for them to finish. So he should have known under these circumstances that he was being arrested. As I said, the officers were in uniform. He knew they were running his name. They told him, put your hands behind your back so you can be handcuffed and arrested. He immediately attempted to flee. Once Deputy Drucker grabbed his wrist to prevent him from fleeing, his elbow flew up into Deputy Drucker's face with such significant force that Deputy Dawson believed, based on his training and experience, that appellant was going to assault Deputy Drucker. So he attempted to get appellant's other hand so they could get his arms behind his back. At this point, Deputy Drucker could not have known what the warrants were for, the severity of the crime. The deputies had not had an opportunity to frisk him, so they did not know if he was carrying weapons. So this was an extremely volatile situation. In People versus Braun, the court found that full compliance with 841 is not required where an officer believes that full compliance will increase their peril. And that was the situation that these deputies were in. They were trying to de-escalate and make sure that they could effectuate this arrest safely.
I'm going to just introduce an element here. Are you familiar with the street term called aroused?
I am not.
Okay.
5 minutes, 5 minutes.
Aroused occurs when an officers just want to stop somebody because they got this feeling in their gut that we're going to get this guy. And so I'm suggesting that some triers of fact or some court would say, are you kidding? It goes back to my first question about who the person is. People have cigarettes, there's not ashtrays in the street. It just looks kind of funny that they would stop this guy. And you're saying, well, they can do it. Yes, they can do it, but there's law and there's the real world. And courts have to look at what goes on in the real world. And there's an argument here that these cops used a highly technical argument to stop this guy, and they're not articulating why they really stopped him. How do you respond to that?
I would say that again, once they found out that he had warrants, they had an authority to arrest him. And under Penal Code Section 834A, he had a duty not to resist the arrest. So once he began to behave as if he was going to flee and then assault them.
Okay, let me ask, I understand your response. Let's assume he didn't have warrants. Were they justified in stopping him?
Your Honor, there is nothing that says that officers have no right to stop and talk to people that they see walking down the street. Officers may stop and talk. And appellant argued the Fourth Amendment unreasonable search and seizure, but that doesn't apply here because the officers merely stopped to talk to this individual. They got his name and his birthday so they could run his name for warrants. They found that he had multiple outstanding warrants. And at that point, they had authority to arrest him.
So your position is the record would support that he could have just walked away if they asked him his name. You're saying
Yes.
it's completely a consensual discussion? Is that what I'm trying to understand your answer?
At that point, he could have just walked away,
Okay.
but that is not what happened.
Could he have walked away when he is, despite the fact that this ashing is maybe not a preferred charge, even in Beverly Hills, they could have used a Starbucks cup to put his ashes in. So, I mean, the fact is, I'm not sure that he could have walked. He could have walked away. He was ashing, and even though it's a ticky-tack call, it's still a violation of the law. You could ask him his name. You could have given him an infraction citation.
Well, when the officers first stopped him, they asked him out the window, hey, can we talk to you? And he stopped and he said, yes. So he could have said no and kept walking.
2 minutes remaining.
Thank you. Appellant discusses, he mentioned the three-pronged test that the US Supreme Court came up with in Graham versus Connor. And he argues that the undetermined warrants alone were not sufficient for the force that these officers used under these circumstances. But prongs 2 and 3 of that test are easily met by the fact that appellant was forcefully resisting after the officers attempted to arrest him. And the appellant's use of force, it does not matter that he did not intend to cause harm to the officers or that he did not direct the violence towards the officers, because there is case law that states that use of force by itself is sufficient to prove a violation of Section 69 of the Penal Code. In People versus Bernal, the court held that forceful resistance of an officer by itself
1 minute.
rise to a violation. Thank you. And then just briefly, the court was properly instructed on the requirement that the officers be lawfully engaged in their duties. First of all, the defense had the opportunity to review the jury instructions and declined to object to them, declined to revise them or modify them in any way. But the jury instructions were complete and the jury was adequately instructed on all relevant law.
I'm sorry. I know you want to,
Okay.
I'll let you sum up. I gave someone else a few extra minutes. The trial court said that they didn't really have to advise him of his arrest because the circumstances are such he should know about it. There are a lot of people that have warrants for traffic tickets and forget all about it. When the circumstances indicate that a defendant should know why he's being arrested, in the commission of a burglary, for example, when the cops go there, they don't have to tell them we're arresting you for burglary. So if you can respond to this, a warrant for, I don't know, traffic warrants, whatever they are, is something that is a little different than someone in the middle of the commission of a crime, isn't it?
Your time is up, but the judge.
I'm going to let you answer that.
I'm not completely clear on your question. Would you
Well,
mind?
I guess I was inarticulate in asking it. I'm saying, isn't there a difference between someone who has outstanding warrants and someone who's committing a crime at the time the officers arrest them?
Yes, Your Honor, but under these circumstances, Deputy Drucker had no way of knowing what the warrants were for, and he had to decide how to react as soon as appellant began to forcefully resist.
Generally, officers know what the warrants are for, I think. Well, anyway, I'll let you sum up. Go ahead.
Thank you. Deputy Drucker only heard the 1015 code, so he was not aware of what the warrants were for at that moment. But based on all of these reasons, we do ask that this court find that appellant's arrest was lawful and his conviction is affirmed. And I will pass the matter on to co-counsel, Ms. Maayah. Thank you.
Ms. Maayah. Okay, thank you. Ms.
Maayah, you have 15 minutes.
You're going to have to unmute.
Thank you. Good morning, Your Honors. May I please the court? My name is Dalia Maayah, co-counselor for appellant for the people of the state of California, the respondent. The trial court is not required to consider defendant's ability to pay before it imposes court assessment fine and fees, as stated by appellant counsel, Ms. Willis. A defendant's ability to pay fine and fees is evaluated in light of his or her total financial obligations, which include the assessments imposed on appellant under California Code Section 1465.8 and Government Code Section 70373. Both of those sections provide that an assessment shall be imposed on every conviction for a criminal offense to ensure and maintain adequate funding of court facilities. These two sections and these statutes justify the $140 imposed on appellant by the trial judge. Furthermore, the California Penal Code 1202.4 Section C states that the court shall impose the restitution fine unless it finds compelling and extraordinary reasons for not doing so, and states those reasons on the record. Defendant's inability to pay shall not be considered a compelling and extraordinary reason not to impose restitution fines. To add to Judge Bendix's question regarding
listen, gotta watch the screen.
Well, you answer you might be answering my question. I'm sorry to, well, my question, let me just say, in finishing your answer, please address, we do appreciate that the assessments and fines were mandatory. What the legislature has provided, but the issue in Duenas was whether it could constitutionally impose that on someone who was destitute. So I don't think the fact that I don't think you need to address that because it's a constitutional argument. No one's arguing what the legislation says.
Of
the
course,
question is whether, as applied here, it could be it was constitutional.
Of course, Your Honor. I will address.
Finish your sentence too, please. You in response to Bendix's question.
Yes,
Yeah.
thank you. I will get to both questions. Let me start with the first one just to add to your question regarding extreme facts of dueñas. Dueñas was a unique and distinguishable case, and it is not applicable here. Many cases suggested that dueñas was wrongfully decided, and several cases have rejected the dueñas analysis and the dueñas decision. She had been caught, as you stated, in series of criminal proceeding driven and contributed to her poverty. So that was kind of like a deviation from the common ruling and decision. The extreme facts of dueñas, they do not exist here. There is no evidence that appellant is unable to work due to any physical, mental, or emotional disability. He was not caught in series of criminal proceeding contributed and driven by his poverty, and he's not trapped in a cycle of repeated violation escalating his debt. And from, as discussed by co-counsel Ms. Patricia Snyder and appellate co-counsel, we can tell just from the facts of this case that he's able-bodied. And as I will discuss briefly in a minute, there is a chance for him to gain incarceration wages. Going back to your second question, if I may, the imposition of fines and fees is not a violation of appellant's due process for the excessive fine clause under the 8th Amendment. In the present case, Mr. Prescott has not challenged the fine as excessive, but rather he requested a hearing to determine if he had the ability to pay the order fines, which were imposed accordingly pursuant to the statute. So the trial court properly denied the hearing. According to 1202.41, the restitution shall be imposed on the discretion of the judge. And here the judge used her discretion to impose a fine of $500, a restitution of $500.
Can I stop you a minute?
Absolutely.
As to that particular financial burden, isn't there a 300 minimum? The judge doesn't have the discretion to pose under the statute at least zero. Isn't 300 the minimum?
Yeah. 300 is the minimum, Your Honor, and the max is 10,000.
Right. So the discretion, zero is not a possibility unless dueñas is upheld.
I'm sorry, can you come again?
Zero is not a possibility unless dueñas. You agree with dueñas?
I do not agree with the case of dueñas, but I was just mentioning the penal code regarding the discretion of the judge.
Okay.
My position is that dueñas was wrongfully decided, and I do agree with the many cases that rejected dueñas, such as People v. Hicks, People v. Casares, People v. Lowry, People v. First Kingstone, and this list just goes on. According to People v. Hicks, the imposition of these financial obligation has not denied defendants access to the court. Additionally, as also you further indicated earlier, the imposition has not resulted in additional incarceration. And in the case of People v. Hicks, the court held that should the fees and assessments imposed, should they remain unpaid at the time of the ending of probationary or incarceration, then the trial court will have to decide whether it was to defendant's indigency or lack of effort. At that point, however, due process does not deny defendants, there was no violation of defendant's due process right. I would like to also mention that in the case of People v. Lowry, the court concluded that we can infer that defendants will have the opportunity to earn prison wages, and they can start paying at least some of those financial obligations. It is illogical to conclude that appellants will not have an ability to pay and begin paying at least some of those imposed fine and fees while being incarcerated.
But you will acknowledge, will you not, that there's a much greater burden on the defendant who's already being sentenced to prison to pay that fine as opposed to someone who has the means to do it. That sentence, if you will, is a greater sentence, a harsher sentence. I mean, isn't that a fact? I mean, I realize he may come into some money later on and all that, but the point is they're treated unequally. That is, the person with means to pay the fine and the person who doesn't have the means to pay the fine.
I would have to disagree with you, Your Honor. Actually, this provides a formality with court proceeding to impose fees depending on the severity of the crime, which is a factor rather than what is their financial status is. That would actually differentiate between different group of people and make the proceeding unfair to treat somebody, a group of people who are wealthy with a group of people who do not have money. I think that would differentiate the treatment.
Okay, that's an interesting argument. It's similar, I suppose, to saying that if you're poor, you'll get a lighter sentence than if you're wealthy.
If there's indigency is involved, we cannot basically punish them for being poor and adding incarceration time to their sentencing. That would be unfair. But in this case,
no, I'm saying giving them a lighter sentence because they're indigent. I mean, I'm following up on your argument. I'm saying I'm finding an analogy. If you're saying, if in your criticism of dueñas, I could see that criticism applying if, say, you gave a defendant who is poor a lighter sentence than someone who wasn't. You were saying that would be an unequal treatment.
Well, I think right off the bat, that would be unfair. And that's where I strongly agree with, thank you. And that's where I strongly agree with the case of People versus Hicks, that at the time the payments are due, and which is not the defendant here was sentenced to 6 years, Your Honor, and he has 6 years to pay those fines and fees, not as mentioned by Ms. Willis, with all the respect, that they are due immediately. They are not due immediately. They are due at the time he serves his time. And
how's he going to pay him while he's in prison? He's going to get a few cents or $1 if he's lucky to get even a work assignment for a day's work, maybe. So, I mean, isn't it unrealistic to really think he's going to be able to make any appreciable payment while he's in prison for 6 years?
They do earn prison wages. That's just an option to pay those.
But I'm saying the prison wages are minuscule. It's money for cigarettes. It's not going to pay this fine.
They can't ask him there either.
He could get.
Well, I think the crux of the issue is, and we look at the Duenas and the Hicks cases, is when the fine is being imposed, it's not being collected when it's being imposed. The guy can't pay, he's going to jail. He may be able to pay. He may be able to liquidate them right away if he's that wealthy. But I think the harm we see in Hicks is when it's being imposed after the fact, and that person doesn't have the ability at that time to pay it, then we have the issue. But we don't have the issue with when it's part of a sentence is to be imposed because you're looking at the future. So I think that the panels disagree with Duane is that Duane is conflating the imposition at the same time as the harm that causes from the imposition. There's no harm yet because he's not being incarcerated for failure to pay. He's being incarcerated for the crime of resisting in this situation.
Sure, and I can't agree farther. I can agree more. You're absolutely right. Even if there was an error, that error is harmless because he's not being incarcerated or punished for not paying the fees immediately. They're not due till 6 years. Sure, Justice Bendix.
I'm having trouble following your argument because you're relying a lot on the fact that one could pay through prison wages, but defendants are put on probation many times, and they're equally poor. So does your argument depend on whether someone's on probation or can get a job in prison, basically, to pay it off?
No, Your Honor, I would still hold my argument the same. And I think the facts of the case of People v. Hicks, it was not a
2 minutes.
present time, it was a probation. And again, if there is no harm right now when the fees are being imposed by the trial judge, assuming there was a violation, that error was harmless. And the court should affirm the trial court decision because there's no additional punishment. And again, there are different ways and things could happen throughout this 6 years period that would make him able to pay. And I think one of the justices mentioned something about solving this problem by doing community services. If we do, that is an option, and I totally agree with you. But if we do actually consider the ability to pay at the time the fees are being imposed and having community service as an option, what I'm trying to say here, it is an option which appellant attorney,
1 minute.
thank you, appellant attorney has agreed with, but it interdicts her argument because if it is a reasonable option as she indicated, how is that going to play a role when you're dismissing the fees and assessment without giving them chance to do community services? Furthermore, and I would just likely to mention that I do agree with her as far as who bears the burden. The defendant bears the burden of proof. And according to People v. Count, which they disagreed with Duenas, which can suggest that the burden should fall on the prosecution. The defendant is in the best situation to know their financial situation and their financial status. And also according to Evidence Code Section 500, it states that the burden of proof should fall on the party or on the party.
Time is up.
May I just conclude?
Yeah, you can finish your sentence. Go ahead.
Thank you. On the party which seeking relief, accordingly, and according to the statutes, we ask the court to affirm the trial court judgments. If the court has no further question, with that, I submit.
Thank you. Thank you.
Your honors.
Mr.
And I think
Sulemazian
Mr.
has 2 minutes of rebuttal.
Mr. Sulemazian.
Respondent is asking this court to hold citizens to a much higher standard than we hold police. I want to first respond to Justice Bendix's question of why the officers didn't just tell Mr. Prescott that he was under arrest and the intent and cause of doing so. Respondent here is misstating the record. On reporter's transcript, page 21, Officer Drucker is testifying as to his thought process. He told Mr. Prescott to put his hands behind his back because Officer Drucker intended to arrest him. However, the issue here is Penal Code Section 841 requires officers to share this thought process with the individual whom they are dealing with. Justice Gilbert, asked about Penal Code Section 841 and whether or not it applies to a uniformed or non-uniformed officer. And respondent answered with an argument about the authority of the officers. However, the authority issue is waived here. The only thing we are looking at in regards to Penal Code Section 841 is the information requirement. The information requirement has never been more important than it is today. Mr. Prescott was scared. He did not know what was happening to him. And when he asked the officers what was going on, the officers must inform Mr. Prescott of what was happening. They had ample opportunity to do so at any point throughout this interaction. The officers ignored Mr. Prescott, and Penal Code Section 841 does not permit officers to create a dangerous circumstance, which would therefore exempt them from this requirement. In that case, the safety exception would swallow the rule here. Police officers should not be able to grab people without warning. Mr. Prescott reacted reasonably under the circumstances.
Well, wait a second. Why do you say that? He had to be tased twice and had to call help, additional officers. All he had to do was to submit to the handcuffing and ask. I'm not sure his behavior was, I would say, was reasonable under those circumstances. I'm curious why you think so.
Your Honor, I see that I'm out of time. May I answer your question?
Of course.
Yes.
Justice Gilbert, excuse me.
No, sure, of course.
Thank you.
Your time is
Mr.
up.
Prescott.
No, I'm just kidding, just kidding. Go ahead.
Thank you, Your Honor. Mr. Prescott acted reasonably because it was the officers that tried to grab him without warning. It's a natural reaction for someone to pull away at that point. That's when the officers then employed the use of a taser. So if the officers scare someone into reacting naturally and then employ higher and higher levels of force, that is not what an objectively reasonable officer would do. And we should demand better of the police here. Thank you.
Okay, terrific. Thank you very much. We're going to be in recess now while we ponder these interesting and challenging legal